So the whole thing with Acheson versus Laufer is they had an argument, and they made their case. The Supreme Court judges and the lawyers, they made their case about all of this in October, and then the judgment, the opinion, was then given in December, and it became official January this year. And I want to talk a little bit about why it's so important and why I think that they're trying to basically hide what they're trying to do here. So today we're talking about Acheson versus Laufer, and this is a case about the ADA. In the holding aspect, Laufer is a tester for the ADA, and it's her job to test for accommodations and access under the Americans with Disabilities Act. Well, a hotel was not providing access, and so, as part of her job, she initiated a lawsuit against them. Okay, well, what happened with that was she wanted to dismiss the lawsuit. In July, she made the motions to dismiss the lawsuit altogether. But they did not dismiss the lawsuit because I think because the reason is they wanted to get their judgments to set legal precedent. And that is why I am concerned now. So, here's what I'm concerned about. And you can find all of the links for my sources on SCOTUSblog.com. And they just do updates on the Supreme Court case. I want to show, first I want to look at this specific article from October 4th, where the justice considers the civil rights testers to sue. That right there is about all of the arguments that are going to be legal precedent going forward about the ADA. And so that's where I'm getting my information from. And so, the first thing about it is, and you'll see where Laufer asked to have her case dismissed in a lower court. And that was because her lawyer got involved in some other shit, and she does not want to be associated with that. So, in July, she asked for, because of those reasons, she asked for them to remove all of this, and they said no at that time. So then they had different court cases about this after that. And so that's what we basically been talking about. So in the lower court, they originally threw out her case, and that's how it got moved to the Supreme Court, because she appealed it. And in the appeals, then they sent that to the Supreme Court. The Supreme Court case, they were basically trying to put into writing that it doesn't matter if a business does not provide access if they don't want to serve disabled people. That's what I'm concerned with here, because the Laufer is a disabled person who tests for access under the ADA. She asked in July to dismiss this because she had issues with her lawyer at the time, okay? They said no because they wanted to make these arguments. I think because they wanted to make these arguments here. Because if the issue, and in the arguments they were saying disabled people don't need to test for access. But if it was really about the case itself being moot because of the whole lawyer issue, then why have the court case? Why not dismiss it when she asked? That's what I want to know. And then I have some other issues with shit that they were saying here. So with the reservation rule is where they were talking about, because she was not planning on doing business there, should she be able to sue them because she is just testing for access for work? She wasn't going as a consumer. So they were trying to say because of that, she shouldn't be able to test for access. So yeah, and then what they were basically saying was because of this issue arising again is why they had the Supreme Court case. So that's why I think I'm right about how they just made the Supreme Court case to make the ruling so they can make legal precedent going forward. And that's where they were saying, like, if because this disabled person wasn't going to use it, it doesn't matter that they weren't providing access for all disabled people, is their argument. And that's what we're seeing right here. And so that's why I'm like, what the fuck? And then they were trying to basically say, right here, it's not discrimination to not provide access to disabled people, is what they're trying to say. So that's why I'm like, this is why I'm like, red flag, you know. And so yeah, that's kind of like how it ended and where it wrapped up there. And where I got this article, it was written by, what's her fucking name? By Amy Howe. And then the timeline of all of this is suspect too. Like, so in 2022, the first petition was filed for the case. Okay, so this is how long. It's like 2 years in the making. So more motions and everything was filed for the case. You know, things are moving along. But here's where the timeline gets a little iffy. So in June, you know, different things are happening with the attorney. And so in July, she asked, you see where it says the suggestion of mootness filed by Deborah Laufer? She asked them in July to dismiss the case. They said no. They said no in July. So if the issue was actually moot to them, why not dismiss the case? Why did they have to make a legal precedent? And they said in their arguments, that's why they were meeting. So, I see what they're doing, and I'm concerned. And then the last, let's see. That's where we're at, okay. So then some more motions were filed after that. So she requested this to be removed in July. They kept having motions and filings and meetings all through August and October and September. Like, they kept going. And then in January of 2024, so this year, the judgment was issued, and the judgment had been made in December. So I don't really know the difference between making the judgment and issuing it. Maybe that's just like the difference in the time it takes between when you say what the decision is going to be versus when you actually write it. I think that's what it is, but I don't know because I'm not a lawyer. But yeah, this is why I'm concerned about the legal issues happening here.